You're tuned in to Agriculture Today, and we start our Wednesday show hearing from K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Thanks for having me, Shelby.
Roger, wanting to talk through a few topics today, and the first one being a blog article titled A Shift in Administrative Enforcement for Agriculture. And what is this shift?
Yeah, this is an article I published on August 31st. It's also up on Ag Manager for people to read. And I'm talking about a case that came down in July. It's from the U.S. Court of Appeals for the Third Circuit. And it's an interpretation of a U.S. Supreme Court opinion that was issued in the summer of 2024 before they adjourned. And it really has, Shelby, I think, significant implications for when a farmer gets into an administrative issue with, for example, FSA, NRCS, any sub-agency of USDA. It has serious implications for that, and positive ones, I would say, for farmers.
And what is a case that had to do with all this?
Well, this was a New Jersey farm that had hired 19 H-2A workers. And the Department of Labor came in and alleged that the farm had breached its employment agreement with the workers by providing or failing to provide adequate housing and meals and transportation and a guaranteed number of work hours, which is all contractually required when you hire H-2A workers. Well, instead of bringing the case in federal district court, of course, the Department of Labor pursued the matter through its own administrative process. And so they've got their own administrative law judge, and that process resulted in over $500,000 worth of fines being levied against the farm and back wages and all of that. So it's pretty serious. And the attorneys for the farm grabbed onto this U.S. Supreme Court opinion, the Jarcasi opinion, late in the term in 2024, before they adjourned at the end of June last year. And they said, now, wait a minute, this is just a private dispute. Yes, it's a private contract dispute, yes, against the government, but it doesn't involve federal tax dollars per se. It's not a tax issue. It doesn't involve Bureau of Land Management, so it doesn't involve federal land. There's no public rights that are involved here. This is a contract that the farm has with the H-2A workers, and that's governed by Department of Labor. And so they said it's really like a private contract. We think we can go straight to court. And that involves a constitutional issue, the right to have your case heard before a jury or your peers. And based on that Supreme Court opinion in 2024, the Third Circuit agreed. And so they were able to bypass the entire administrative appeal process.
So you weren't always able to bypass that administrative appeal process?
No, before the Jarcasi opinion came down by the U.S. Supreme Court last year, administrative law, and I've taught this way to farmers and attorneys for many years, is that you got to be careful to make sure you properly exhaust all of your administrative remedies because you can't go to court before you do that, which means you're going to have to hire an attorney. You need to preserve the record because the only thing the court's going to do when they get it from an administrative agency, from a final determination with that agency, is they're just going to review the record to see if any procedural mistakes were made. But basically, if their determination was reasonable, if it wasn't just simply arbitrary and capricious, the agency would win. Now you can bypass that. And our data showed over the last 40 years that a farmer had a really low chance of winning in an administrative appeal process and a much greater chance of winning if that case were actually appealed further to a court. So this kind of bypasses the agency being their own judge, jury, and executioner. And you can get to a jury of your peers, which is the constitutional issue that the court was addressing here.
What happened with that New Jersey case?
Well, once it got there, what happened was the court agreed with the farm and said that, yes, you can bypass the administrative process, and you didn't waive your Article 3 objection because the Department of Labor never informed the farm about their right to refuse administrative adjudication. And so they were never really given a choice. So what happens is that the Department of Labor's enforcement action was unconstitutional. And so those fines, those penalties go away. And it's going to change the way that I think federal administrative agencies prosecute matters, the way they deal with participants in their various programs. And of course, for our farmers and ranchers, this is a big deal. And I'll be emphasizing this at farmer seminars and attorney seminars that represent farmers that, look, here are the situations where you're still going to be stuck in the administrative appeal process. But we've got another branch here of disputes that your clients may have, your farm clients may have, where we bypass that process and can go straight to court. Save money for the farmers, greater chance of winning.
And you've mentioned a few things about taxes and that not working. What are some scenarios where you really can't bypass the administrative
Yeah, that's
appeal?
a good question. Yeah, because there's a public rights exception here. And that public rights exception the court emphasized is, well, when we're dealing with, for example, an argument that the IRS has with the taxpayer, that's dealing with public taxpayer dollars in that situation, not funds that have been appropriated for a particular program. And then you have contract issues associated with that, which is what this was. Or, and the court said, if you have a dispute with the Bureau of Land Management over grazing rights on public land, that's where the public rights exception to the getting to an Article 3 court would apply. But those didn't apply in this situation, and they said this farm, this was unconstitutional as applied. They can go directly to court.
So if, per se, a farmer or rancher does get in trouble, important to find someone to represent them that knows about all of this?
Yeah, we're still in the process of educating attorneys on this. The Jarcasi opinion by the U.S. Supreme Court was just last year. So it's a learning curve to get attorneys up to speed on this.
And Roger, another recent blog article titled Making a Citizen's Arrest, Is It Permissible? If so, is it a good idea? And is it permissible?
In Kansas, it is. And in some states, it's not. About 35 states, it is permissible in one way or another. And we actually have a statute on this in Kansas. And this has come up recently. A number of years ago, there was a situation in the Wichita area that gave rise to citizen's arrest. And now we've got the same thing happening in Western Kansas. So that's why I wrote this article. I put this out on September 6th. Again, available also on Ag Manager and my blog. And I cover it in my treatise on agricultural law. It's in my civil liabilities chapter as to when you can make a citizen's arrest. And then we'll talk about whether it's a good idea. But in Kansas, you asked if you can. Yes, we have a statute on it. It's 22-2403. And you've got to meet the requirements. A felony has been or is being committed, and the person making the arrest has probable cause to believe that the arrested person is guilty of that felony. So that's kind of tricky there. What's probable cause? And it has to be a felony. It can't be a misdemeanor. And then the second part of this is, well, for any crime. So now it opens it up beyond felonies. You can make a citizen's arrest for any crime other than a traffic infraction or a cigarette or tobacco infraction that is being committed by the arrested person in the view of the person making their arrest. So the first one doesn't have to be in your presence. Has to be a felony. You have to have a reasonable belief that a felony was committed. Second one has to be in your presence. Can be any crime other than a traffic infraction or cigarette or tobacco infraction.
But is it a good idea?
I would suggest against doing it because you might get shot. You might get beat up. Something bad may happen to you. You never know. I would warn people about that. One, you got to do it right in accordance with the state law. And so that's the first thing. Do you know, are you for sure that you're dealing with a situation that's covered by Kansas law? And then you need to, if you do it, you need to report the arrest immediately to the appropriate authorities, whether that's the police department or the sheriff's office. Do that immediately or as soon as possible. And then remember, you better be prepared to testify in court because you're probably going to get sued in many of these situations. And you need to provide evidence of the arrest and the circumstances surrounding that. And before you do it, think about your safety and the safety of others around you in case you get a negative reaction out of the person that you're arresting, and then try to take steps to minimize that potential harm. You do all that, God bless you, go ahead. It's your choice. But I would probably caution against it.
Is every state the same as Kansas?
No. That's a great question. The states vary. As I said, about 35 states allow it. Some have no statute, but their common law allows it. Some don't. Some states in their statutes don't require a felony to be committed in your presence. Some require it to be committed in your presence. They're just all over the board on their approaches because the states have deemed whatever the policy is in their state to fit their particular citizen. So it does vary from state to state. But there's still about 15 states where you can't do this.
Roger, can you remind us where people could read these blog articles?
Yes, they can find it on my blog. That's accessible through washburnlaw.edu/Walter. And then I also share them with K-State. It's on the Ag Manager website through the Department of Ag Econ.
Roger, I appreciate you taking the time to join us today.
Thank you, Shelby.
That was K-State and Washburn Law Professor Roger McEowen. If you'd like to read more on these topics, I will link the blog articles in today's show notes on agtoday.net, or you can find them for yourself by going to washburnlaw.edu/Walter, or by finding them on agmanager.info.